I will call our first case of the morning, Berlin Revocable Trust versus Rubin. Good morning.
Morning.
This is a calendar case, 20-minute argument per side. As you know, you may reserve time for rebuttal. You both have 2 minutes of a free fire zone, which you may waive. And please begin when you're ready.
May it please the court, Mary Massaran, on behalf of the defendant's appellants, I'd like to reserve 4 minutes for rebuttal. With me at counsel table is trial counsel Tom Maher. The recent Michigan Court of Appeals decisions barring the short-term rentals based on a restrictive covenant amount to a retroactive judicial nullification of Michiganders' settled expectations that persons who own vacation homes can rent them for a weekend, a week, a month, or more. The court can take a fresh look at the question since no decision from this court has yet interpreted a generic property restriction limiting lot use to single-family residence purposes. The overwhelming majority of state Supreme Courts have held that the phrase limits how a home is used, not who can own it or how often or for how long they can rent it. And this is not surprising since the phrase single-family residence purposes does not mention rentals at all, let alone include a duration. Plaintiffs urge this court to bar some undefined duration of rentals by judicial fiat, even though the words in the deed, taken singly or as a whole, do not do so. Michigan law provides that the tie goes to the free use of property, and it's intended to prevent just such a draconian after-the-fact change in a property owner's rights. Yet the lower courts have enjoined all short-term rentals, even when a property owner only rents once or twice a year. An unusually broad group of amici, the NAACP, realtors, the Michigan tourism industry, and property rights advocates all agree with defendants' position on this. This court should reverse and squarely hold that a restrictive covenant for single-family residence purposes does not unambiguously bar short-term rentals.
Counsel, it's nice to see you again today.
Thank you.
I'm wondering, I know we haven't decided this issue squarely in this space, but obviously we tackled it in O'Connor. And I thought the court did a pretty good job in that case, trying to sort of figure out what is residing in what is a vacation home. So why doesn't that apply here?
O'Connor, the specific question in O'Connor was whether that kind of phrase, residential purposes, bars interval ownership. Interval ownership, as this court said in O'Connor, is qualitatively different than ownership by which someone has the freehold interest in their residence. And that's all the court held. There's dicta in which the per curiam opinion picked up language from the trial court discussing sort of residential purposes and various aspects. That's certainly not controlling. And as a per curiam decision issued on a different topic, I don't think it provides much guidance. And what's happened is it's led to all of this confusion by which the Court of Appeals has repeatedly glommed onto this phrase or that phrase from dicta in the decision to adopt a position that's squarely at odds with the language in the restrictive covenant and with the longstanding principles that this court has articulated about how to interpret restrictive covenants.
It wasn't entirely clear to me. Do your clients use the property themselves, or is it only held out for rentals?
They own the property, they bought with an intention. They each have long-standing family relationships in the areas. And as the plaintiffs and my clients use those properties, none of them are using them except, I think, two who are not parties on either side of the dispute. None of them are using those properties as a permanent residence. which is another problem with the Court of Appeals reasoning, because the Court of Appeals is saying, well, domicile means permanence, and if you adopt that as a controlling principle, what it means is all the rental housing that exists in single-family residential districts all across the state is in violation of deed restrictions like this, and may also be in violation of zoning, because that single-family residence purposes has never been understood to bar rentals per se.
So, I mean, I think it's safe to say your client couldn't turn the home into a bed and breakfast.
Correct.
So, I mean, this is where obviously we're bumping into like a challenge, is like, does it start to look like a hotel, and is that different? And I guess, why is it different?
Let's talk about the specter of hotels, motels, and rooming houses for a minute. This court has said in the past, in Hardwick, in Dingaman, in Seeley, and Nerderer, that single-family residence doesn't allow lodging houses, rooming houses, and so forth. Our position is not at odds with that long-standing law. A bed and breakfast and boarding house is qualitatively different. First of all, the breakfast makes a difference. When you're serving meals as a part of your staff services for people who you are leasing rooms to, all of a sudden there's a whole different layer of laws that come into play in terms of food safety, inspections, et cetera. It's a whole different.
Right, but I would think, okay, let's say a rooming house, the old, which we don't see that much anymore, but used to be very common. You'd have a rooming house with individuals in different rooms, probably not breakfast, maybe, probably not. What's the difference?
Well, in a rooming house, as you say, somebody is leasing one room. They're not leasing the premises to operate as a single housekeeping unit in the same way that a family who lives there all year would be using the premises. And it seems to me that makes a difference that should matter in the law and does matter in our view, but would allow the short-term rentals, would not allow rooming houses, boarding houses, bed and breakfast, because they're qualitatively different.
So under your position, are your clients allowed to rent to 20 different, I suppose there's fire code regulations or something, but they can fill up the house with as many people as they want, no matter what they're there to do? Can there be restrictions?
Well, the Court of Appeals barred all rentals. That would be if somebody owns their property and leases twice a year for a month, one time to 2 people, one time to 4 people. It's a very broad injunction that just simply can't stand. In our position, and the focus of the litigation throughout has not been on the language in the deed about it has to be a family by blood or no more than 3 persons. The plaintiffs concede that no more than 3 unrelated persons is inconsistent with this court's jurisprudence defining family in the context of land use, and we agree with that. That was never their effort, though, to say, hey, you can do short-term rentals, but you're renting to too large of groups. That's just not what this case has been about. And so to inject it now, I would say, is a mistake to shift the focus. What the focus has been is you cannot have short-term rentals. In terms of the rentals that have gone on, there have not been any that have been anywhere near 20 persons. They have been, as far as the record shows, 12 or less, and many of them have been smaller than that. And certainly the numbers have been spread over years. It's not like it's being rented, either of these properties, nor any others around the state necessarily are being rented to 20 different people each day.
Counselor, I understand you to be saying that this isn't clear on its face, that this is an ambiguous provision, right? So we have to interpret that. And in all of the pleadings, there are a bunch of different interpretations. There's the composition of family that you indicated that we're not sort of here to decide. There's what does the physical building look like, and everybody agrees this is a single-family structure. And so really the three other alternatives are, which I think you're proposing, is the use of the property. What is the person inside of it doing when they're doing it? And then I think that the plaintiff would suggest that it's maybe the use of the owner of the property, and so here the owner is using it in a more commercial way, or to the duration of the property. And so what language, either in the covenant or what in our case law, if the case law is open, what should we look to decide among those different interpretations?
Well, the court's body of law is very clear that the tie goes to the free use of property. That's the first principle. Here, the courts from around the country, if you look at the Pandahari Panda Tennessee Supreme Court case from 2023, or the Whitby case from Connecticut, or the Eggman case from Oregon, all of those have a good discussion about what does single-family residence purposes mean? And what they say is, at best, it's susceptible to two meanings. One of them is that a building is used as a dwelling place for one family at a time, which would allow short-term rentals. The other, which Brother Counsel is pointing to, and which the lower courts, in our view, erroneously have latched onto, is the idea that it's a place one family intends to live with some permanence over time. And given that ambiguity, it seems to me the conclusion is inescapable that the lower courts are wrong and the tie goes to the free use of property. Court should not interpret ambiguous terms to take away sticks in the bundle. Defendants bought their property knowing that the rentals had been going on. In fact, one of them spoke with both the president of the Homeowners Association and its secretary, both of whom said in writing, and this is in the record in emails, that although they'd like to have some rules to limit it, the property owners had the legal right to engage in these rentals. It was only after that that they couldn't figure out.
But were the past rentals, and I know this is like very hard lines to draw, I mean, I recognize that's why this case is here. If a property is held out full-time for rental, is that different than one that's held out part-time for rental? Does one start to look more like a commercial use?
I don't believe so, and I think this idea, first of all, let's remember, this deed has no ban on commercial use. This court said in Miller versus Ettlinger, which is a very old case involving apartment buildings, where the owners were renting the apartments and it was limited to residential use, the court said the fact that they're making a profit on rentals doesn't alter the fact that the apartments are being used for residential purposes. And that principle is controlling here. The use of the property at any given time is a single family use, the single family that's eating, bathing, cooking, relaxing in the home, just as they would be whether the owner lived there all year round or whether somebody rented it for some other durational period.
You just used the terms residential use and residential purpose almost interchangeably. Is there a difference between single-family residential purpose, which is used in the deed, and residential use, which you can also find in the deed?
I would say single-family residence purposes is the strongest case for a reversal here. And here's the reason why. Some courts talk about resident or residential. Here, use of the term purposes shows that the term residence is being used as an adjective. It's describing how can you use the property. And the single family is limiting it, saying you can't have a double housing, as this court said in one of the, I think, Boston Edison cases. There's a limitation, so you can't
This may be the-
duplexes are less a thing than they used to be, but you can't have a duplex if it
Okay, but
says
hang on
single
a second. This
family.
might be the first time in 30 years that you didn't answer my question.
Oh, I'm so sorry.
Is there a difference between single-family residence purposes, which you like, and residential use? I can find both terms in that deed. Is there a difference?
I think residential use is defining how the property is used. And single-family, I'm not sure there is a difference.
Okay.
I'm not sure there is. Residential use is defining how is the property used. And this court and courts all across the country have repeatedly said that's for bathing, sleeping, eating, et cetera, et cetera. Single-family residence purposes adds the idea that you couldn't have an apartment building, you couldn't have a duplex if it's single-family. And it's emphasizing that the use of this structure is for residence purposes, which gets you to that same list of activities.
So, all right, but you essentially said you weren't sure if there is a difference. To which
Correct.
I would rhetorically say, then why do they use different terms? But let's move on to something else. You want a finding of ambiguity. And I know you know Michigan Supreme Court jurisprudence probably better than half of us up here, including me. What is the standard for a finding of ambiguity in Michigan?
Michigan courts have said, in order to find an ambiguity, you have to have two different meanings that can't be reconciled with each other.
Equally susceptible understandings, correct?
Correct.
If it tilts ever so much in one way, then there's no ambiguity. We go with that route.
Correct. You have
Okay.
two meanings that can't
And so
be.
here you do believe it's two equally susceptible interpretations that don't tilt either way.
I think, as many courts around the country have said, the term can be understood not to say anything about rentals, and I would pick that meaning. But if the court has any doubt, then it seems to me, given the strength of the case law, looking at it with this idea of permanence, and I think conflating it with the idea of domicile, which is a whole different inquiry, at a minimum, it would have to conclude that the terms are ambiguous. I hope I've answered your
Okay, no, you
question.
did. Thank you.
I have less than 3 minutes left, so maybe I should save the rest for rebuttal.
Thank you.
Thank you.
Good morning, Your Honors. Steve Van Semper for the Appellees, the Berlin Trust, and the other homeowners. I just want to start with a couple points here off the top. First of all, when the courts review or construe terms in a restrictive covenant, they have to be construed in their ordinary and popular sense, not in a hyper-technical sense. So we're looking at, okay, what did the drafter mean, kind of in an ordinary sense, when the drafter used these particular words? Single-family residence purposes, right? And I think the most obvious answer is the drafter probably meant the same thing that this court has held repeatedly and other courts in Michigan have held repeatedly for decades. Single-family residence purposes, right? It means that has to be a non-transient use by a single housekeeping unit. So if we take that apart a little bit, we talk about the term residence by itself. That has a non-transient connotation. We see that in the Wood case, for example. It says residence has to be a place of abode. Again, you can't abide in a place overnight. And so there's a quality of non-transience that's built into when something's a resident. And we talk about, we go through in our brief about all the different ordinary ways in which the term residence is used, which excludes transient or temporary stays. So as an ordinary matter, right, nobody would say a group of 14 people renting a place overnight are using that as their residence. That's not the way that ordinary people would use that term. And the same thing for the single family part of this. So single family is actually specifically defined in the restrictive covenants. It means, who's a group of people with whom you're biologically related, or it means a small group of people who are all maintaining a common household in a residence. And again, as a matter of ordinary meaning, nobody would say that a group of up to 14 people who, pay lodging tax and pay a property manager when they stay overnight in a building, that they're using that, or that they're maintaining a common household in a residence there. Again, that's a,
Is this an all or nothing proposition? Is it such that either all rentals are allowed or all rentals are barred?
no, absolutely not. No, so the difference is transients versus non-transients. So, so you could have certainly long-term rentals that are non-transient uses of property, that's residential. So obviously a year-to-year lease would be non-transient. And arguably a month-to-month lease would be non-transient. So you could rent a property for a month and that would be perfectly fine. But because the dividing line, I think, for purposes of this discussion, is between transients and non-transients.
So the owner lives in the home 51 weeks out of the year and then decides they want to go to Alaska and see something different and puts up on whatever Airbnb to rent for 1 week while the owner's in Alaska. Does that violate the covenant?
I think the rental itself probably would, because the rental is the non-transient use, right? The owner's use of the property the rest of the year would not. And so, but I do want to back up a little second, because I think even when you have some of these edge cases, right, it may be difficult to tell, okay, is this use transient or is it not? The fact that it may be difficult in certain circumstances to apply the test doesn't mean that the language in the covenant is ambiguous, right? The language in the covenant still has meaning, even if it takes some work to apply it to specific factual scenarios. So for example, the Teal versus Goings case, which is from this court a couple years ago, that was the modular home case. And so the question there was, the restriction said, you can't have a modular home on the property. And the question was, well, what is a modular home? And the court, it didn't rule that that term was ambiguous just because people had different interpretations of it. It said there is an ordinary meaning, it's not ambiguous, and what it actually means is, predominantly modular, like more modular than not. And then you take that definition and you go and apply it to the facts before you, and you say, okay, well, here's a home, it's got prefab windows, prefab doors, prefab roof, is that predominantly modular or not? So the same thing happens here.
I still have PTSD from that case. I think the question wasn't whether it's modular or not. The question was whether it was stick-built. Deemed required to be a stick-built home.
Right. Obviously, Your Honor,
I still have like I said.
Exactly. So, but the same analysis happens here, right? Where you have words in a covenant. Those words have meaning, right? We figure out what the meaning of that is, and then we apply it to facts of the case. And we may say, look, there may be edge cases where, for example, you may have a homeowner who has a vacation home and they show up there every other weekend. Is that transient use or not? Can you have episodic transient use or episodic non-transient use? Again, I would say you can, right?
The transient use is nowhere in the deed. It's simply residential, right?
Well, exactly. So it says single-family residence purposes, right? And as we've articulated, in the word residence, when this court has looked at the word residence, when they say, okay, property has to be used for residential purposes, that implies that somebody's using it as an abode, right? And again, you don't use something as an abode overnight. So the word residence by itself excludes merely transient stays. And the same thing for single family, right? So the single family housekeeping, or the single family restriction limits it to a single housekeeping unit. And this court has said, for example, in the City of Livonia case, that single family restriction, it applies to groups of people who aren't related to each other, right? So like the group of priests in the Boston Edison case, and then in the City of Livonia case, there was a group of folks in a group home. And this court said, citing or quoting from Malcolm versus Shaley, says, this is why this constitutes a single family, or this amounts to a single family use, because the facts in the case at bar do not connote a temporary living arrangement. The inhabitants of the foster care facility will live there on a permanent year-round basis. Now again, so the difference is between transient use and non-transient use. And that's what the O'Connor case does as well.
So the same question that I asked opposing counsel, do you view there being a difference between the terms single-family residential purposes and residential use?
So I wouldn't read the restrictive covenant that technically, right? Because again, we're looking at the ordinary meaning of, the plain kind of ordinarily understood meaning. That technically
that they have different meanings?
I'm sorry?
You said you wouldn't read it that technically, and I don't know what you mean by that. that technically that these two terms would have different meanings?
Correct.
Okay,
Yeah,
so
right.
you would say there is no difference between these two terms?
Right, I would say ordinarily, right, what the, as an ordinary matter, I would say that the restrictor here, the person who drafted the words, meant to restrict it to residential use. And residential purpose, residential use, I think, for purposes of an ordinary meaning analysis, are going to be generally the same thing. And again, the term residence itself has a necessary component of non-transience to it. So,
So can I, just to clarify, is it your position that the Court of Appeals was correct that a vacation home cannot be single-family residence purposes? And the example that Justice Zara gave of the 1 week, you live there 51 weeks, you rent out 1 week, that is also violative of the covenant?
so I do not, frankly, I don't think the Court of Appeals was correct with respect to the vacation home, right?
Okay, and why?
Because of the transience part of it, right? So the question is somebody using this property in a non-transient way? If you own a vacation home, if you own a summer home, and that is your home, you're not renting it out serially to other individuals?
So,
that-
I mean, I'm struggling with that these words, I get that, like, we're all talking about different line drawing of like what is 1 week here, family vacation, 20 people, no, but, 4 people who are related, yes, and we're drawing the lines. Aren't we asking an awful lot of those 4 words, single-family residence purposes, to draw those lines for us? And the Court of Appeals drew it one way, reading those words, and you're saying, well, no, actually, that's probably not right. But you would read it this way and oppose, I feel like we're working really hard to find that there isn't an ambiguity, and these words are supposed to be drawing the lines for us, and that's what I'm struggling with.
Well, so I appreciate that question. This court in Wood, right, that's the pigeon racing case, right, they have the racing pigeons in the garage or whatever. They said this about that. They said, no clear and definite line can be drawn as to residential use of premises, right? So the question is instead whether the property is being used as an abode. Now again, so in terms of, there are going to be fact scenarios where you take, okay, is this single-family residence purposes, and you look at it and you say, boy, it's really difficult to kind of figure out whether this particular fact fits or not. But that's perfectly compatible with the way that the cases have worked, right? Ever since Wood, through O'Connor, and then through the unbroken line of Court of Appeals cases as well, right? I mean, the position here, I think, from the appellants is that, there's chaos and there's confusion in the courts of appeals, and there isn't. O'Connor, ruled the same way. And O'Connor, when you read O'Connor, it talks about continuity of presence. It talks about relative permanence, right? That's making the distinction between a transient use of the property and a non-transient use of the property. That's what O'Connor is doing.
Tell me, if, say this weekend, I'm going to visit my daughter in college in a town that has very few hotels, and I'm renting an Airbnb for the weekend, in part so that my daughter can stay with me and I don't have to stay in her dorm, right?
Yeah, of course.
And you're saying that kind of use is not using it as an abode. How would I be using the property then? I'm using it because it has a kitchen, it has multiple bedrooms, it has a living room, and it's not a hotel room. If I'm not using it as an abode because I'm I'm transient, right? I'm using it for 2 nights as opposed to, I don't know, more than half or 90%, whatever
Sure.
the line is. How am I using it if not as an abode?
Sure, you're using it as an overnight guest, right? You're using it as a place to stay on a short-term basis. And I think,
Well, that feels sort of circular. That seems like the duration as opposed to the use. I'm not using it as a place to run my business. I'm not using it as a place to host a TV show, as like a studio. I'm using it to sleep and eat and live.
right, so exactly. So the question, I think, is do those specific activities, right, sleeping somewhere, eating somewhere, relaxing somewhere, does that mean residential use, right? And, some courts say that it is, but this court has said that it's not, right? Dingman says, those are just incidents of life. That isn't enough to make you a resident of some place. And that makes sense, right? Because if you think about short-term rentals in this particular neighborhood, Swift Estates, right? If you think, well, who are the residents of Swift Estates? It's my clients, the ones who actually live there. It's not somebody who stays there overnight. They're not residents of that neighborhood. And I will.
Is there a difference between a residence and a dwelling in this context? A dwelling is a permanent, you plan to return, that type of thing. Residence obviously has, in other contexts at least, has a less sort of permanent meaning, correct?
Well, I think the ordinary meaning of residence is actually that it does have, it's a relatively permanent stay as opposed to a temporary one.
What's a dwelling then, under the common meaning?
So a dwelling, right, that's a, if you're dwelling in a place, then you're abiding in a place as well. So I think dwelling is actually perhaps, I mean, that's relatively similar to a residence, right? If you're using it as your dwelling, if you're using it as your residence, I think those are fairly interchangeable. And
Even though they've been defined differently in case law generally.
well, again, so I think the ordinary meaning of residence is one that requires something that's more than just temporary.
Okay.
So, yeah, it's interesting, because Justice Kavanaugh raises an interesting question about her weekend Airbnb and, you know, how she's using it, but then sort of like, but does duration matter? I mean, it seems to me duration does impact how it's used. I mean, isn't that?
So exactly,
The
Your Honor. So part of an aspect of how a property is used is whether it's used for transient stays or not, right? And again, I mean, I'm a fan of Airbnb too, right? I mean, so if a community decides to open itself to Airbnbs, obviously that's perfectly fine. It's perfectly legitimate. It's just that when a community has said, we're limiting use to single-family residence purposes, that requires a particular use. And again, it's, you know, again, our clients and the drafters of the, or drafter of the restrictions, they don't, it doesn't matter who stays there. There's no line drawing about who can stay there and who can't. It's just about how the property is used. That's the only thing that matters. It could be anybody as long as the use is being, as long as the property is being used in a non-transient way.
How do you respond to Sister Counsel's arguments about the fact that these homes were held out for rental for many years, and it seems like it probably wasn't a problem, and people, I don't know whether they were either ignoring the restriction or just thought the restriction allowed for it. How do you respond to that?
Yeah, so that was actually a claim that was raised in the trial court. It was rejected in the trial court. It was raised in the Court of Appeals. It was rejected in the Court of Appeals. Because those kind of rentals were of wildly different character. So for example.
Yeah, tell me how.
Yeah, so there was an instance where an individual who had purchased one of the lots was building their home, and their home didn't get finished on time. And so they had a couple weeks where they needed a place to stay. And so then one of my clients said, okay, here, you can, you could use my place for a bit. There's a small rental fee or whatever. And so they stayed there for 2 weeks. That's the sort of rentals that we're engaged in beforehand. Now again, after all of this came up, this is much different, right? The uses here from the.
But in that example that you just gave, were they intending to stay in the place that they were renting?
The people who showed up?
No,
the people who rented?
The renters.
The renters.
No, exactly.
They were
no.
transient, so by your own definition, it doesn't fit within it.
I agree, right? But the fact that, so what happened is that in the trial court, the other party said, look, you guys have waived these restrictions because you violated them. And the trial court said, no, that claim is, those rentals are fundamentally different, right? There's not a permanent holding out of the property. They're not marketed online. They're not overnight rentals, right? Because here we have rentals
that takes me back to my 51-week example.
I'm sorry?
That takes me back to my 51-week example, which you said would violate.
Right. So the fact that some of these properties were, that folks rented some of them beforehand, those activities may have violated restrictions as well, right? I'm not disputing that.
But it was tolerated, and it's not waived because here we're doing it a lot more than we did before.
Well,
that's essentially what I'm hearing.
So essentially what happened is that there were some, minimal rentals, to family members, strong referrals, whatever, not to people on the internet, no property management company involved. And then after for instance, this LLC purchased a house and then started renting it on the internet, then suddenly people are like, wait, are we actually allowed to do this? And they went and they got legal advice, and at that point they realized, oh, you can't actually do this under the language of the restrictive covenants. And so, and then they made, they made an argument that said, well, you waived your arguments here, and the trial court said no, Court of Appeals said no, and that's not at issue here anymore. They've dropped that claim. The Court of Appeals ruled against them, and that's no longer at issue.
Yeah, and I think O'Connor, there was a similar waiver argument that this court rejected. So.
Exactly.
So there's like this tension where, I mean, we know there was a crossover in time where something happened. And I'm wondering, is there, again, sort of that distinction between, is it different, Justice Zara's example, versus somebody who only rents out all the time? Is there a difference? I know there's not a commercial restriction, but it does say single-family residence purpose. So is there a difference between those?
So I think so, right? And again, each of these cases is going to depend on the facts, right? And so there may be, for example, episodic continuous use, right? So you may have a person who owns a vacation home and then, but shows up only every other weekend or something, right? Now that may very well be a non-transient use. And it's going to depend on the facts of the case. It's going to depend on how the restriction is specifically worded. But that is going to be depending. And here, of course, again, as a matter of ordinary meaning, right? As a matter of ordinary meaning, nobody would say that a group of 14 folks who rent a place overnight are using it as a residence. Nobody would say that they're using it, they're maintaining a common household in the property, right? As a matter of ordinary meaning, I just don't think that's escapable.
Counselor, when you're saying this is very fact-specific, I might assume that sister counselor might say, well, but there's an importance in having a stable and permanent and clear understanding for how people can use their property. So I'd invite you to respond to that.
Yeah, sure. So there is, right? And that has been articulated in the case law from this court for decades, right? So O'Connor, right, is an example of that. Right? The differences between a continuity of presence, relatively non-transient use versus transient use. And the Court of Appeals has interpreted O'Connor the same way for 25 years.
So give us an example in this circumstance with this property of where a rental, follows our prior case law.
So it may very well, a month-to-month rental may very well be fine.
A what?
A month-to-month.
Month.
Right, 30 days, right? So Hensley versus Gadd, the Supreme Court of Kentucky, they said, look, if push comes to shove, probably month-to-month, because a month-to-month lease, that's a fairly typical non-transient lease term, right? Now the question is, okay, well, is it, 3 weeks and 6 days? Well, that's where you get into questions of, okay, well, then you're gonna have to look at the particular facts of the case. How are they using the property? How are they marketing the property? How are the groups that show up? Are they all maintaining a common household, right? That's when you get into the facts of the case. It's just like the modular home case, where you say, okay, we've got our definition. It's not ambiguous. Let's go to the facts and let's figure out, okay, is this more or less modular or not? It's the same analysis here. You have an unambiguous definition, and then you go and you apply it to the facts of the case. I'm out of time. Thank you.
Well, that was good timing.
Yeah.
Well done.
Thank you.
A couple of points on rebuttal. First of all, our clients do use the property for 3 weeks of the year in July and August, and they and their family members stay. I don't believe that's relevant one way or the other, but the question was asked, so I want to respond. Second, just listening to Brother Counsel's argument and thinking about the briefs, it is apparent that this language, which nowhere discusses rentals, nowhere limits them, as many deeds do, only rentals for 30 days or more, only 2 rentals a year, only rentals for 60 days or more. No language like that is in this deed. Third, when there is an ambiguity or a failure to clearly limit something in a property deed, the court's jurisprudence uniformly says the tie goes to the property owner. It doesn't ask, our jurisprudence doesn't ask this court to weigh and balance hundreds and thousands of separate cases coming from each individual renter from now until eternity to figure out what their property deed meant. That kind of a rule would create chaos in the real estate market, not to mention in people's personal lives, because it's so unclear.
Your brother counsel says this isn't a tie. This is just a hard application of a clear rule, or a rule that if you apply it that way, it doesn't end up in your favor. So it's not an ambiguity, it's not a tie, it's just a hard question depending on the facts. Why is that not correct?
Well, brother counsel says nobody would assume his definition of transience counts. 15 other state Supreme Courts have disagreed with him, and they have all said that language doesn't unambiguously restrict short-term rentals. And listening to the failure to come up with some kind of clear answer that this court can include in an opinion underscores why those courts were right. When somebody purchases property that has no limit, let alone as here, when the officers of the HOA have said in writing, you have a legal right to rent your property, and then because the neighbors don't like some rental or whatever, they want to use the courts to impose a line drawing exercise that's nowhere found in the language of the deeds. That just isn't consistent with Michigan property law, and it isn't consistent with common sense. And so we would urge this court to reverse. I'm happy to answer any other questions.
Thank you both. The case will be submitted. Appreciate your time.